And it now falls to me to welcome again Vera Baird and ask Vera to deliver her keynote speech. Thanks. Over to you, Vera.
Thank you very much indeed, Les. And I was delighted also to make the acquaintance of Alex. And I'm very pleased, as the Victims Commissioner for England and Wales, to be asked to address the Northern Irish Human Rights Commission on this important annual occasion. And how I wish I were there in Northern Ireland talking to you in person. I have a significant connection. My oldest school friend has lived here for many, many years, and it was only just before COVID separated us all from many of our friends that I last visited her. And prior to that, I came to meet with Judith Thompson, your very special kind of Victims Commissioner, on the same occasion as I attended a conference about the Gillen Review, and it's the way to progress in the first year. The talk I'm going to deliver first found airspace in the organisation Justice in England and Wales, of which Les is a significant trustee. I did some cases for Justice when they were tackling miscarriages of justice almost single-handedly. And what I am not talking about today is that kind of hard injustice. Nobody in the position of a victim of crime is going to be wrongly imprisoned. And nothing I say about future treatment of victims detracts in the slightest from the centrality of the defendant's fair trial rights. We must draw a red circle around those rights. And when we've done that, we can improve the role of victims and witnesses hugely without coming anywhere near that circle. For 20 years, I was a defense advocate, and that lives with me still. But victims can, and they do, suffer injustice from their treatment by the criminal justice system, from disregard by the agencies to re-traumatization by the process itself. And it's pretty easy to see why. In a historical context, victims, if wealthy enough until the advent of the centralized state, brought a claim against an alleged wrongdoer for redress, and that was the criminal justice system. As the centralized state emerged, it changed to the current situation where crimes are seen as an attack on the state and not against the victim. So proceedings are not there to put right the victim's wrong, but to enable the state to inflict punishment where appropriate and affirm the rule of law. If a case is brought, the victim can be compelled to be a witness, but not to talk about what's happened to them, merely like a bystander, to tell the court what the defendant did. In the adversarial system, the defendant is at the centre of the court process. The prosecution prosecutes him, the defence defends, the jury determines guilt, and the judge ensures the trial is lawful. This centrality is not to be criticised. However, all the agencies lean in toward this focus and see victims as temporary and marginal, at best, as one academic has put it, witness fodder. Yet, victims might have suffered serious injury, sexual assault, or the death of a loved one. They're intimately involved from the day of the offence throughout the process and often beyond far into their future. The notion that the state prosecutes on behalf of the whole public does not capture that special individual involvement. And by failing to do so, it fails to assure that the rights needed to support victims are delivered. So the criminal justice system, which can't function without victims, needs to adjust its perspective to see them as valued participants and to support them appropriately. The rights they need are no challenge at all to the defence. They include things like help to understand the process, updates on the case, respectful treatment. Often they also want the voice to be considered at important stages, but not to take the decisions. But the exercise of such rights helps victims to recover from victimhood and restore failed to protect them from crime in the first place. So it's time for that change to occur. At present, all pointers suggest a decline in confidence in the criminal justice system in England and Wales, partly caused by poor treatment of victims, which they currently complain about, many of them to us. By statute, I'm not able to get involved in individual cases, but these complaints do come to our office on a day-to-day basis, the lived and poor experience of many victims. So, of course, there are victims' services. Core Victims Services are government funds commissioned locally by our police and crime commissioners. Police refer victims to a victims hub following a report of crime. Those are there to give practical, personal, emotional support, to help victims to cope and recover. These are the watchwords. They have a quite separate operation from the criminal justice system and rarely have much to do with it. Separately, at court, witness care units run by the police are there to improve witness attendance by helping with the practicalities of getting them to court. At court, the court-based witness service, volunteers from the Citizens Advice Bureau meet and greet. These two have little to do with the victims' services. Two things do stretch across the services and the criminal justice system, and the first is a series of professional supporters funded in England and Wales, as I think also in Northern Ireland, independent domestic violence advisors, or independent sexual violence advisors, or independent victims advocates for a generality of victim of high harm crimes. They are specialist victim services for victims most effective. They liaise with the court for their victim. Client, go with them, accompany them to give evidence. In some courts, all of these representatives are welcomed. However, in others, they are not even allowed in. And sometimes an ISVA, for instance, has supported a victim for many months. And as they come to give evidence at their most stressful time, the ISVA is not allowed to be there. The other support for victims at court, which stretches across, as it were, care of the victim and the court process, is special measures introduced, I beg your pardon, in 1989 to help witnesses who are intimidated by their position or assessed to be vulnerable by the police. They're to give the best evidence they possibly can, are things such as giving it from behind a screen, across a television link. Special measures have really meant that a lot of victim witnesses who would probably have been quite unable to give evidence can now do so. But just as ISVAs, etc., are not fully accepted by the court, special measures are not provided universally well. Research shows that while police assess 9% of victims and witnesses as potentially vulnerable and entitled to special measures, just screening with a professional questionnaire, though a simple one, shows that actually 54% are potentially vulnerable. There are, of course, entitlements to a minimum standard of service in the criminal justice system set out in the Victims Code for England and Wales, a brand new one, just come about. There are 12 key rights. Could I first ask you to note that these are not enforceable in any way? So if enforceability is the hallmark of a right, these are not rights at all. In addition, they're not expressed as rights in the code. Take right 6, where police and CPS are considering an out-of-court disposal. You have the right to be asked your views and to have them taken into account. Where this is not possible, the right continues, the police or CPS will tell you why not. So the right seems to me to be confined to being told why I can't have my right. Consider part 8. Right 8 is when attending court to be able to enter through a different entrance from the defendant and wait in a separate waiting room. The recital of the right continues. Some court buildings don't have separate entrances and they don't have separate waiting rooms. But if they're informed, the court service will do their best. Bluntly, people who've had a family member killed will come to court and we can't guarantee them a right not to sit next to the defendant whilst they wait to give their evidence. it's clear that these are not rights. They are favours done, if it's possible, to the deliveries by the delivery agencies for the victims. If occupying a separate waiting room were a right, the court service would have to find one. But at present, they merely note they haven't got one and do what they can, which may not be very much. Rights 3 and 6 are to be provided with information about the case and updated on important decisions. Right 4 to be referred to victim services. Right 7 to make a victim personal statement. This February, my office analysed victim data from the Crime Survey for England and Wales, which the Ministry of Justice doesn't analyse, the victims sector. Most victims were satisfied with their initial contact with police, but 52% of victims reported that they quickly grew dissatisfied with how the police handled their case, taking too little action, not communicating about the case. Rights 3, 4, 5 and 6 require keeping up to date and communicating well. Where an incident was reported to the police, just 10% of victims had contact with victim services, though the rule is the police must refer everybody to victims services unless victims categorically decline. This is right 4. These are examples of victims' code rights, but our analysis shows that only 20% of victims of crime during that year who've been involved with the criminal justice system had ever heard of the Victims Code. We do, in my office, an annual survey about the victim's personal statement, right 7, to be told about a victim personal statement and help to have one. For 6 years in succession, my predecessor as Victims Commissioner, I've just been in post a year and a half, reported that fewer than 1 in 5 victims recall being offered a victim personal statement, and this fell to 1 in 7 victims this year when I did a similar report. So altogether, that's a quick run through, roughly 8 of the 12 rights that are just not being delivered. In 2009, Ministry of Justice statistics showed 67% of victim witnesses who'd given evidence would do so again at court. CPS research in 2016 showed that only 53% of victim witnesses who've testified at court would be likely to do so again. 53% might. That means 47%, or almost half of victims who've been to court wouldn't go near it again. Now, under the Victims Code, rape complainants, with others, are entitled to enhanced rights. That's better treatment. Yet we've done a recent survey that shows that far from receiving better treatment, many rape complainants found the criminal justice system a hostile environment. I know that considerable work's been done in Northern Ireland to review and recommend change in how serious sexual offences are dealt with, and there's a part heard rape review in England and Wales too, and so many of Sir John Gillen's recommendations in Northern Ireland are featured in our review, and if I have much more to do with it, they will feature ever more strongly. Our survey was to help that government rape review. 491 rape complainants responded. Many of those who'd reported to the police said that they had felt disbelieved, they had felt judged. 95% of the respondents who did not report said that that was because they thought they would be disbelieved. 88% of that same group saying that they thought they'd be disbelieved because of, quote, my gender, my sexuality, or my lifestyle. You may think that these who didn't report were sadly proved correct in their reservations by the experience of those who did report. CPS decisions to drop cases were described as devastating, and some were described as unjust because they thought that avenues were not pursued, evidence not considered. All in all, 14% of respondents agreed with the statement that they would get justice by reporting an incident to the police. Worse still, 75% actively disagreed. Home Office figures show that 43% of sexual offence complainants now won't proceed with a case. 49% is the figure in personal violence cases. Across all kinds of cases, 24% of victims who've reported won't proceed with their case. This last figure has tripled since 2015. What we're seeing is the failure to deliver victim code rights and thus poor treatment, contributing to low confidence in the criminal courts system. I won't go into court backlogs caused by cuts in our case and made worse by COVID. Some trial dates are now in 2022. The failings I've set out long predate COVID and will long survive it unless there is change. So next year in England and Wales, there'll be a victims law, a chance to deal with the fact that victims' rights aren't working, aren't enforceable, and are rights only as long as the agencies responsible want you to have them. Recently, we spoke with government officials looking for targets around victims, including they proposed a 50% increase in awareness by victims of their rights. Now, we said that given that awareness is now 18%, a 15% increase would come to 27%, and that would look pretty silly as a target because it is so pathetically low. They said, however, that they'd had a real battle with the police and CPS to get even that, and you may think that says it all. The police, the CPS, the courts will all try to be nice, but nobody thinks it's their role to deliver victims' rights. In 2016, my predecessor researched what works in supporting victims of crime. Victims seem to want what's in the Victims Code, more or less, and what they're not getting. Information, an understanding of how the CJS works, updates on decisions in their case, collaborative working across criminal justice agencies so they have one SPOC, professional victim services, procedural justice, which procedural justice is just a respectful acknowledgement that wrongdoing has happened, listening empathetically, letting them know their entitlements, taking reasonable action. Victims place as much value on how they are treated as they do in getting the right verdict. This is at the core of why victims' rights are important. They're restorative. They tell people that contrary to having been demeaned by their criminal treatment, they are valued by society, and the CJS will treat them with respect and will deal with the matter. It's a kind of therapeutic justice, and obviously it has its limitations. But at the moment, many, many victims are made worse by our criminal justice process, and that has got to stop. So care of victims in these really simple ways is the kind of other half of the justice which the criminal justice system needs to deliver, and is quite separate from the justice to the defendant, which, as I've said innumerable times, has to be totally protected. It's clear that the next victims law should say that all the agencies must deliver code rights, rewritten as rights for victims and not concessions by the agencies, and that they must all provide what isn't available now, an accessible complaint system specifically for victims about the code. Currently, you have to go through the police complaints, CPS complaints, the court service complaints, and really there isn't a lot further to go. Sometimes it's not even possible to allocate the responsibility for a particular failure. So we need one single system. What form redress for breaches should take, well, ideas vary. I can tell you there was a brief whimsical reference in a press story recently to the Victims Commissioner having the power to fine police officers and Crown Prosecution Service personnel. I don't think so, to be honest. There are MPs who think failing to deliver victims' code rights should be a disciplinary issue. That failure and the consequences are yet to be decided. But there also needs, of course, to be a framework for annual compliance so that we can protect victims of events needing to complain and not worry about some sort of fining. The police and crime commissioners are going to collect data about the implementation of the Victims Code locally, though slow progress, data is not good. The overview of the compliance with the code should come to the Office of the Victims Commissioner, statute requires me, quote, to keep under review the performance of the Victims Code, but it doesn't give me any power to do it. And that needs to change to provide a mechanism for a systematic annual review by our office to be in our annual report laid before Parliament. Enforcement, discipline to implement the code looks inevitable, but it's a shame. I think agencies would support victims if they saw them as key participants. And I suspect if they got extra resources specifically to deliver rights to this side of cases. So the participant victim is a concept that we're thinking about, that I'm mentioning to you. The victim in their own case has a very different interest from yours and mine as the public. The late Lord Steyn, with the approval of other members in the House of Lords case, Attorney General's reference number 3 in 1999, said, of course, there must be fairness to all sides in a criminal case. This requires the court to consider a triangulation of interest. It involves taking into account the position of the accused, the victim, and his or her family and the public. He reiterated the same point in the Crown Against A number 2, which is a rape case. It's well established that the guarantee of a fair trial under Article 6 is absolute. A conviction obtained in breach cannot stand. The only balancing permitted is in respect of what the concept of a fair trial entails. Here account may be taken of the familiar triangulation of interests of the accused, the victim, and society. In this context, proportionality has a role to play. He puts it, obviously, far better than I do, but this notion of triangulation recognizes separately in a proportionate way that the victim has a participatory role to play closer than we, the detached public, separate from that of the prosecution who represent us, not as a party, but as an important separate participant. The 1985 UN Declaration of the Basic Principles of Justice for Victims of Crime gives some backing to separate victims' rights within the CJS, particularly at Article 6. Judicial processes should allow the views and concerns of victims to be presented and considered in the proceedings where their personal interests are affected. European human rights case law can also be, to some extent, prayed in aid in Dawson and the Netherlands, observing that Article 6 fair trial rights under the Convention don't reference victims, but that their life, security, liberty, or privacy rights, which might be at stake in a case, are protected by other rights. The court said the principles of fair trial require that in an appropriate case, the interests of the defence are balanced against those of witnesses or victims called to testify. We've done a report which we'll publish at the end of next week about what happens in other jurisdictions to give delivery of victims' rights. And in Victoria, Australia, their Law Reform Commission in 2016 recommended the role of victims should be conceptualised in accordance with modern jurisprudence. In the modern trial, there is a triangulation of interest: the public, the accused, and the victim. Within that triangulation, the victim of the criminal trial is not a party, but is a participant. That's now in the law, in the Victims Charter Act there. The point of redefining the role of bystander to that of participant, as I've entitled this lecture in Victoria, is to bring better practical treatment. And that would be the point of reconceptualizing it here. So a victims law in the UK, giving victim participants a statutory set of enforceable minimum guarantees which support them to participate, would be a comprehensible principle. Let me add, for some victims, participation will be satisfied by information and support, but for some, it will involve being able to challenge decisions that directly impact upon them. So this is not new. The police and the CPS both are subject to a victim's right to review, a scheme that lets a complainant request a review of any decision that will put an end to their case. So a decision not to charge, for instance. This year, a judicial review in the High Court established that in the Crown Prosecution Service victim's right to review, there is a fair opportunity for a victim to make submissions to get a favourable decision. The CPS have always said that their victim right to review scheme only lets the complainant request a review, doesn't give them the opportunity to seek to influence its outcome. The court said, no, this is an opportunity to make representations, and if they're made, the CPS must respond to the representations made about why the charge should go forward. This is strengthening the victim's role in charging. Remember from our research in rape how devastating victims found decisions not to proceed. And it follows through on the right to a voice through a victim personal statement to be heard on sentencing. Let's be clear again, the victim participant view is not determinative here. CPS, police, the judiciary make the decision that victims need to be heard. That separation of the victim's right from the state is highly relevant to the victim's right to privacy under Article 8 of the Convention. Prosecutors who find anything on the victim's mobile phone or in health records which they think might undermine the case or help the defence have got to disclose them. However, the triangulation of interests recognised by the House of Lords and to some extent internationally and now clearly in Victoria means that a victim can ask for a proper balance to be struck with their privacy rights. This is an interest that isn't capable of being represented unless it is understood that the victim has a separate role from that represented by the prosecution on behalf of the rest of the detached public. It may be vitally important, though, for a complainant. It doesn't undermine the right of the accused, because if a finding that the balance favours the victim, it would merely rule out what would otherwise be an unfair forensic advantage and not a defendant's legitimate right. To do this, to challenge disclosure, victims need representation. The Information Commission has reported this year that CPS have been over-intrusive, the Crown Prosecution Service, in its requirements for complainants' confidential material, and this has contributed to quite a decline in support for CPS in the court. In a sense, their role in the adversarial system means that the CPS can't represent the victims' interests in disclosure issues. Their obligations are very clear, and so in part they're getting blamed for what they can't do. So as an organisation, they, and similarly the police, can benefit from the recognition of that separate interest of the victim participant so it can be properly represented. So nobody would pretend that this is a fully realised new vision of the victim's role, but there is an urgent need for victims to be recognised as participants with an inherent interest from the day of the crime throughout the criminal justice process. And they must be entitled to rights that respect and support that role and help them personally toward recovery or restoration. This is so important if our fellow citizens who've been harmed by a crime are to be helped to recover, but equally essential, frankly, if we're to have a functioning criminal justice system. There is some firm grounding in English and Welsh jurisprudence and in some Commonwealth criminal law for recognising that interest of the participant and acknowledging them as separate from the interests of the state, which simply cannot fully represent them as if they were simply disinterested members of the public. Currently, in the adversarial system, victims are no agency's direct responsibility. Everyone will be as nice as they can, but systematically it's all missing. So it seems to be better to think in terms of a picture of a victim, undoubtedly in fact a participant and affected by the process, in the hope that that picture helps police, CPS, court service to see that rights flow from that position and their need to be treated with decency and, if possible, restored by their experience of the criminal justice system. And actually, being treated with decency is all that's required. Thank you very much.
Thank you, Vera. I should know after 9 months of when to unmute myself. Thank you. That was a tour de force. I'm going to hand you over now to David Russell. I can see that there are some questions and comments. So David, I'll leave you to facilitate this part of the event.
Thanks, Les. Vera, we have a few questions in for you already. I'll maybe give them to you one at a time, so you can handle them that way, if that makes sense. The first is a general comment regarding compliance, I guess, with international standards. The comment was that the UN Special Rapporteur has made reference to the duty of care to victims to fully investigate reports of abuse, including historical behaviours, and whether you have any thoughts about compliance currently of the system. And specifically, there was a reference made to the actions of the CPS in England and Wales.
There is a very real concern in England and Wales now, although it is not, I think, as widespread as it should be, about the current approach of the Crown Prosecution Service. The position is that there appeared to be a change of policy. The CPS would say it wasn't a change of policy, it was a tweak in 2016-17, but it was a tweak that was driven across all rape and sexual assault lawyers by the Director of Legal Services of the Crown Prosecution Service, which is not disputed. I was the Police and Crime Commissioner in Northumbria when they came there to make sure that tweak was driven through. I'm using their term, as it were, as a tweak. What happened was, within a year of that change being driven, charges of rape had dropped by 1,000. Over the preceding decade, there were always more than 3,000 charges of rape per year, getting to 3,900 at one time and 3,700 in the year before this happened. But charging dropped by 1,000 during that year. Importantly, police referrals continued throughout that year at the same rate. There is not to do with a fall off of police referrals. In the second year, prosecute charges dropped by a further 1,000. And now, whereas we did get to 3,900 a few years ago, the figure is 1,800 cases a year, which means that significantly fewer people are convicted either, with real concern. And the figure well known in England and Wales now is that of the vastly increased number of complaints, and it has absolutely gone up at the same time, there are now prosecutions of 1.5%. 1.5% of rape complainants even get a prosecution. There is real concern about that, and it has played a key role in a fall of confidence of a kind that I represented in saying how many victims of alleged victims of rape just won't make a complaint, can't stick with it, don't feel believed. There is a judicial review of the Crown Prosecution Service pending as to whether that was a change of policy and whether if so it was unlawful, and that will occur in January. And in my view, whether it's lawful or not, it needs to be changed back. But that judicial review is clearly going to be very key indeed, and one can see why there are real questions over whether the UN Special Rapporteur's approach is being fully adopted at present.
Thank you. The second question is with regards to the Domestic Abuse Bill, England and Wales, and specifically the amendment to remove the rough sex defence, and whether you could say something about that's the development of it, and more specifically, how you think it could be best advocated for in Northern Ireland, where there's a similar debate going on. And currently consultation out on it, as you probably know as well.
I didn't know there was a current consultation. I knew it was being debated. So there were a couple of significant cases. I mean, one was an international one that you have been apprised of as well as us. But there was one particular case that hit the headlines, I think, to some extent because the man was very affluent and had a lot of expert help in the case. But the point of it was that there had been, a whole sequence of events which resulted in injuries that ultimately caused the death of this individual. And his defense was a kind of mixture of, well, the serious ones didn't happen in sex, but all the other ones did. And he, in the end, pleaded guilty to manslaughter by not, when she was unconscious at the bottom of the stairs, calling in any medical assistance. He went off to bed. So that was his conviction. It wasn't any real responsibility for the injuries, which seriously offended, I think, a whole lot of people. So the defence is now an amendment in the Domestic Abuse Bill. And I mean, it was advocated very largely on the basis of that case, but we assembled together, as maybe your advocates have too, a case file of other cases in which it had featured. I mean, it is only, as far as we're aware, ever been used by men about women as a rough sex defence. And clearly it's, you know, it's the kind of ultimate deprivation of bodily autonomy of a woman. And it appears at first sight and to possibly run a risk for a defendant, but a closer look at it convinced everyone, I think, that if he didn't have an intention to cause really serious injury, then he would have a defence, even though he couldn't say it was part of rough sex. So it looks as if it can exclude the application of that defence without injuring the defendant's right to what's basically at stake here, which is what was his intention at the time. That case file is very much available if it's of assistance. And the arguments in Hansard, in the chamber itself, which were pursued particularly by Harriet Harman, are very salient ones to adopt.
Just following on from that, I'm just going to jump down the question slightly. There's a query has come in about the sensitivities about police, prosecution and judicial independence, and whether that is an unsurmountable barrier to better victim and witness care. I was wondering whether you have any thoughts about that.
I mean, I don't think it is an insurmountable barrier at all. I think that, as I've said, decisions of that kind are for the professionals, but they've got to be open to challenge, and in particular, they've got to be open to challenge by people who have a direct personal interest in the decision-making process, and that's what the victim's right to review is in both cases. And as I think I said in my lecture, no one's suggesting that the decision should be taken away at all, but what should be done is the right for somebody who would otherwise not have a voice in it to have a voice in it, so that the police can consider an all-round picture, the defendant's interest, the complainant's interest, and the public interest, exactly as Lord Steyn advocates.
Then a slight change of tact. A question came in earlier about the debate surrounding whether a victims commissioner should be created for all types of crime in Northern Ireland, and in addition to those that are troubles related. And what lessons you think have been learnt from England and Wales from your own experience, and also what pitfalls, I guess, should be avoided if one were to be created here?
I mean, I'm not a person who ought to be expressing a view about how you run things in Northern Ireland. So I think that my role, and I've met Judith Thompson, and she has a very narrow remit. I think, you know, she seems to me to be really effective, but she hasn't got the remit that I've got. So what I think is the use of a victims commissioner, even one without any power like me, except the sound of my voice and my ability to build alliances and so on, is that there is always someone looking for the victim's perspective in everything that comes forward. A perspective which is frequently missed by those who deliver services and those who create policy. Although they think they are taking into account the victim's perspective, it's a bit like John Lewis's customer service manager thinking they're doing a good job for customers. Actually, you have to ask the customers, and you need the customer's representative to have a voice and to have alliances to make sure that that perspective isn't just, a rehashed, rather rose-coloured view of how things are going. It's been very, very evident during the post-COVID rebuilding of the courts it took me fully 3 months to argue my way onto those rebuilding committees, which are led by the judiciary, but contain all the service deliverers, the courts, the police, the CPS, etc. They didn't have anybody at all to represent the victims, except of course all of those bodies thought they were, and they couldn't see what on earth I wanted to be on it for, because, you know, after all, I'm there to develop victim policy, not to talk about operational matters. But it has made a very significant difference. I have a phone call every other Tuesday with the victims hubs who deliver victim services. They are in police areas, so there are 40 of them, and we have a sample who undertake, you know, the Wales one rings all the other Wales ones, and the Northeast one rings all the others. So we get a small conversation with a big representation, and they have been feeding in through me matters about how victims are not being dealt with properly as the courts rebuild, which have made a significant difference to how they will be dealt with. I mean, they're still not, it's far, far, far from perfect, but it's having a victims commissioner means that the government's appointed somebody who they expect, you know, to be a thorough nuisance on behalf of victims all the time. And if you can do that, you know, with great charm, as well as with great gusto, and I probably manage the second rather than the first better, then nonetheless you can get good access to all the places where it's important to be. There's a sort of obligation to give you some access. I think a victims commissioner is a good thing. I've only been in the role 18 months, but I'm thoroughly enjoying it, and it's growing all the time.
David, can I just add, I've had a number of conversations with Judith Thompson when she was in her role, and I know that one of the frustrations for her was that she was confined to dealing with victims of the violence, and it was a frustration for two reasons. One, that the victims sector is deeply divided, and it meant the association of the victims commissioner role was often to do with division in terms of how she may have intervened or what she may have done or said. And second, there were times where there were clearly issues which were not troubles related, but raised really significant issues for victims, and the victims commissioner could not intervene. So I know from kind of practical experience of those, and I noticed Mike Nesbitt, I'm not sure if he's still here, is a victim, you know, previous victims commissioner, but there is a need for somebody to play that kind of public voice role that Vera and her predecessors played, and it's not possible, it wasn't possible for Judith Thompson to do it, and unless the remit is made more broad, it will continue not to be possible. And I think that is a downside of the provision we have in Northern Ireland.
On the back of that, we've also had a question in, which is sort of the other side of the coin, about an equally narrow remit for a commissioner, and a debate about whether there should be a specific domestic abuse commissioner in Northern Ireland. And the feedback from the department in particular that money might be better spent providing support to victims and survivors. So I guess, Dame Vera, whether you have any views on the balance there between remit of a commissioner versus support for victims and survivors.
I do think that the emerging of a domestic abuse commissioner, although Nicole Jacobs hasn't yet got her powers since the legislation's not yet gone through, has been a really useful adjunct. Domestic abuse is so huge now that it monopolizes a great deal of time, police, prosecutions, courts, etc., and as a significant presence in society in terms of support services. I think that does justify a domestic abuse commissioner looking specifically at that remit. But of course, we overlap because domestic abuse victims are just as much victims as every other kind of victim. So we work very closely together as well. The point I think to be made as quickly as I may is about funding victims services. Of course, they need to be funded absolutely adequately and on a sustainable basis, which they rarely are. It's usually short term and insufficient. But unless you know through some central leadership figure charged with promoting best practice, charged with keeping under review their rights, given the task of producing research about themes of victim concern, then you're not going to know how well to spend your money and where to spend it. Because there really is, as I tried to say in a microcosmic way in my lecture, not a lot of contact between victim services and those who deliver the criminal justice system. They think there is, but they are not talking in the same language. And you do need somebody who can reach out to the stakeholders and file their concerns with the powers that be.
Les, that's all the specific questions I can see. So participants are being very helpful at the minute, in that they're helping us stay to time. I have one other question which came in earlier, but I think it's more for yourself, with regards to what are the three challenges in relation to human rights in the health sector in Northern Ireland. But that seems more one for you, if I'm right.
I think it is. I recall in my first week as a Chief Commissioner, I inherited a public inquiry into healthcare in emergency departments. So when at that time I should have been looking to find where the coffee was in the kitchen, I was chairing a public session with the then Minister for Health, Edwin Poots. I think there are three challenges that I would look at. One is structural reform. We don't need another review. We've had Bengoa, we've had Compton. We have to start grasping that, and that's a real challenge, because it then begins to intercede on kind of local issues about how we configure our hospital and healthcare services. The second one, which is related to that, is we have a health and social care trust system, but social care and health are not fully and properly integrated, particularly around healthcare services. It became very clear in the Commission's inquiry that often discharge issues were impaired and hindered by the lack of social care provision and the ability of social care to run deftly. And unless and until we get social care properly resolved, we will always have that problem. And that's a problem of funding, both centrally and in Britain at local authority level and here elsewhere. And the third one is the current and contemporary one, is how do we manage current services whilst also managing the pandemic? And we've had a number of really difficult cases that have come to us in the last few months about treatment being delayed in really quite difficult circumstances because of the pandemic. There's a legal case going around waiting lists early in the new year. It's not our case, but we submitted a letter to the court in that. And my kind of final observation on healthcare, and this arises more widely, as ever, some of the reform and some of the change is down to spending more money, but by no means all of it. And we need to have an adult conversation, and this is one that's exercised the Commission in terms of economic and social rights. How do we begin to fund better public services? And one of the parts of the New Decade New agenda was the setup of a fiscal council, a kind of equivalent of the OBR in Britain. And one of the things I would frankly love to see there is the start of a conversation about tax varying powers. It's not politically popular, but we know that putting taxes up per se is not politically popular, but putting taxes or varying taxes in order to hypothecate extra money for certain public services is. And if we want to move away from a sterile debate of, well, if we spend more money on health, where it's coming from, or we want to spend more money on housing or on mental health in particular, or education or anything else, then we need to start to think about tax and social justice. And human rights has begun to really embrace that through people like Philip Alston and both his successor and predecessors as UN Special Rapporteur for extreme poverty. And I'd like to think that the Commission might be at the heart going forward of some discussions around tax and justice, which is one of the motivations for the piece of work we did on the cumulative impact assessment of tax and social security policies, because it became clear that while the rhetoric in the early 2010s of government that we're all in it together, it was actually those at the bottom end who were paying largely for the being all in it together to deal with the recession. So I hope that kind of answers Estella's question, or at least gives some food for thought.
I think we can finish up there, Les, then. Over
Yeah,
to
well,
you.
I know that Vera Baird has to go for another meeting. So look, thank you, everyone. I really kind of regret that we can't do what we would normally do, which is chat to people before and after the event, offer you, frankly, tea, cup of coffee, a chance to meet Dame Vera in person. But I hope that you find the annual statement useful. I hope that it was a tour de force from Vera Baird. I'm familiar with some of that speech from Justice. So thanks again, Vera. I know how busy you are, not only just in this day, but generally, and really appreciate it and look forward to hopefully being able to host you in Northern Ireland in person soon. And thanks to everyone for coming today. Please feel free to give us feedback on the annual statement, and I just hope you find it useful in terms of your work in whatever work that you're involved in. So thanks everyone, and have a happy Christmas if it's not too early to say that. Thanks.